Hello, New Media Law class, and welcome to this lecture on digital music law. And the first piece that I want to look at is the background of technology, copyright, secondary liability, and fair use. And this is a theme that we've been talking about already throughout the semester, and it becomes particularly important, as you'll see, in the case law, which is pretty significant on digital music. To get into this question, we actually have to go back to a Sony case in the Supreme Court. And I mentioned this case in class last week. I have here on the screen a picture of the early Betamax machine. And as I mentioned in class, this was an analog tape recorder that you could hook up to your TV and record broadcast television. And at the time, a number of media companies actually brought a case to enjoin the sale of the device itself, saying that the device was facilitating infringement. Now, factually, there were some interesting pieces in the case. There was survey evidence done showing that most people who were using these devices were using them to time shift. In other words, they, were at work and there was a show on that they wanted to watch, so they record the show and they can watch the show later. The surveys at that time did not show any decreased television viewing in general by owners of these devices. And in fact, there were some media companies that didn't even object, that didn't join in the case, and these in particular at the time were professional sports leagues who thought that it actually might be good if people could tape the game and watch it at another time. So the first piece of the case deals with this question of vicarious liability or contributory infringement. And of course, vicarious liability is a concept we're all familiar with. We're familiar with it from agency law, from tort law, and the court here notes that this is a kind of liability courts are familiar with. But here, the only connection between Sony and the user was the point of sale. Now, normally vicarious liability is that there's some degree of control, responsibility, supervision, like a principal and agent, employer, employee. But here, Sony is just selling a device. So it's difficult, the court said, to see how there can be some kind of vicarious liability if Sony is just selling a device. Another way to look at it is, does copyright law govern devices? And the court says there's really no precedent under copyright law or any kind of intellectual property law that just the sale of an article of commerce can be contributory infringement. Now, it's true, as the court recognized, that under patent law, there was and still is a doctrine that says if you sell a component that is put together in a finished product and the finished product with the component infringes a patent, the component could be, the seller of the component could be liable for contributory infringement if that component is not generally a staple article of commerce. In other words, if it's really specifically designed and the only real use for it is to combine it into something infringing, then there could be contributory infringement. But if it's just say a gasket that can be used in a whole bunch of different kinds of applications, a car engine, a plane engine, other things, and it just that particular gasket happens to be used in a device that when put together is infringing, the general sale of the gasket is not going to be contributory infringement. And that's the analogy that the majority in the Sony cases is drawing here. And so they're saying the sale of copying equipment, the sale of something like the Betamax, is just like the sale of any other article of commerce that does not in itself constitute a contributory infringement. And this is important language. The court says it has to be capable of substantial non-infringing uses. And the court did find, as we noted, that it was capable of substantial non-infringing uses. Now, why is it a non-infringing use for an individual user to time shift? I mean, aren't they making a copy? Well, this is where the Sony court gets into the question of fair use and says, is the direct use, the individual user, infringing, or is their use a fair use? And so we've talked a little bit about copyright fair use before. Copyright fair use is a fundamental component of copyright law. It is in the Copyright Act. It is not intended to be merely just a narrow exception to copyright law, but it's a fundamental part of copyright law. And there are four basic factors in a fair use analysis. What is the nature of the use itself? What is the nature of the underlying work? What is the amount and substantiality of the portion used? And what is the effect on the market? And so here the majority looks at this and says, well, what is the nature of the use? And under the law at the time, kind of the jurisprudence under fair use at the time of the Sony case, the courts tended to look at whether the use was adding something, was creating something new. Now, under current jurisprudence, we would use, we would talk about whether it's a transformative use. And whether or not now the use is commercial is still something we'll look at, but it was something that under the nature of use factor was probably more important under some of the older jurisprudence. In any event, here the court says the use is not a commercial use. It's broadcast television. You can watch it without charge anyway. So the fact that a user is recording it to watch at a later time is not a commercial use and is not presumptively invalid. Now we might raise a question about this and say, well, what about the fact that it's possible to zip through the commercials? Now we might raise a question about this and say, well, I mean, isn't it possible to zip through the commercials? Aren't the commercials what support the market for broadcast television? And that might be a fair comment from our vantage point. We're used to digital. We're used to being able to do that fairly easily. It wasn't quite as easy to do that with the original Betamax. As to the effect on the market, the majority said whatever evidence there might be about harm from time shifting was merely speculative. There wasn't any real direct evidence that anybody was not watching television or that it was negatively affecting ratings in some way. Now there's a dissenting opinion in this case, both on the question of fair use and on the question of contributory liability. So on the question of fair use, as I mentioned, the purpose and character of use factor today, we would really mostly talk about whether the use was transformative. So under the jurisprudence at this time, some of it would talk about whether the use was a productive use and whether it was doing something kind of socially beneficial. And the dissent says, well, it's not that kind of use. It's just an ordinary use for personal consumption. Now this is going to be important or interesting in any event when we look at the Napster and the Grokster cases and how the Napster case treats fair use. The dissent says the majority ignores the nature of the work. This is a creative work. And this also is a really important piece, this discussion of the effect on the market, again, when we get to the Napster case, because the dissent says, well, maybe it's not hurting very much the existing market for broadcast television, but what is the potential market? What is the future market for broadcast television? And what is the future and potential market for recorded television? And the dissent is suggesting that the ownership of the copyright has at least a certain bandwidth, not only over the precise existing market, but also over potential future markets. That was not the majority's view, but the dissent took it up, and it gets taken up in the Napster case again. The dissent also says, the majority just really discounted the amount used factor because the entire work was copied. Then on the question of secondary liability, Justice Blackmun said, Well, in dissent, said the question whether a significant portion of the use is non-infringing is really a question of fact. And this is an issue that ought to go to a jury, and in individual cases, a fact finder should examine it. Again, the majority in this case thought that they had enough ability to look at it without it having to go to a jury. Now, just to note, there are ways that Congress could get involved in this kind of issue and really sort of deal with it, attempt to deal with it on the front end. And here's a picture of a digital audio tape. You can see kind of the size of it, relatively small. And what happened with that technology is Congress said, well, we recognize that this can be used for somewhat larger scale infringement of music. It can be used for other things as well. It's unlikely to be found contributorily infringing under the Sony case, but what we're going to do is impose basically a tax on the sale of the equipment and allow that tax to be part of a compulsory copyright license. Now, interesting idea, and as I said, MP3 technology really displaced digital audio tape, really never took off in the market as a kind of consumer technology. So it does raise questions about, will this kind of solution actually get superseded by the market itself, even if you do try to adopt it?